Today we are going to start as a subcommittee of the Public Safety Committee. Just a quick announcement of the items on consent. The items on consent, AB 1672 by Mathis. Item 8, AB 1730 by Atkins. Item 9, AB 1731 by Atkins. Item 10, AB 1744 by Cooper. Item 16, AB 1962 by Dodd. AB 25, item 25, AB 2221 by Christina Garcia. Item 27, AB 2278 by Linder. Item 31, AB 2417 by Cooley. Items 33 and 34 have been pulled from today's calendar by the authors and will be set for next week. So we have a number of authors here. Assemblymember Bigelow is here. Item 18.
Good morning, Madam Chair and members. I'm here today to request an aye vote on AB 2012. First, I will accept the committee amendment to add San Luis Obispo County to the bill. AB 2012 will authorize the Board of Supervisors of specific counties to authorize the county sheriff or the county director of corrections to create a jail industry authority. Industry programs provide benefit.
Assemblymember Bigelow, you do have support on both sides. So,
Madam Chair, I will take that as a tremendous sign. So with that said, I do have a couple of members who traveled to be here today. If you would, I have Mr. John Fisher from the Tuolumne County Sheriff's Office and Lieutenant Wayne Billett from the Los Angeles County Sheriff's Office. If you would afford them a moment since they traveled to be here, I would greatly appreciate that.
thank you.
Good morning, Madam Chair, members. Lieutenant Wayne Billett on behalf of the Los Angeles County Sheriff's Department. This is a very important measure to help our inmates to learn life skills, work skills, earn money, and earn time credits. And for that purposes, we urge your support. Thank you.
Madam Chair, members, John Fisher, Tuolumne County Sheriff's Office. We co-sponsor this with Los Angeles County. It's a great program to let little counties or small counties or different counties to actually learn teach trades and skills for the inmates that are in their certain counties, and we totally support this.
Thank you.
Good morning, Madam Chair, members.
Sorry. Please.
Corey Salzillo on behalf of the California State Sheriff's Association in support.
Thank you. Others in support? Are there speakers in opposition to the bill? Okay, one other quick support.
Good morning. My name is Tanisha Boatner on behalf of the California State Association of Counties in support. Thank you.
Thank you. Are there speakers in opposition to the bill? Seeing and hearing none, would you like to close? And we will take a motion as soon as we have a quorum.
Looks like we might be close, so I would just encourage an aye vote from all the members, and thank you very much.
Thank you. Actually, we do have a quorum, so we will call the roll.
Hancock.
Here.
Hancock here. Anderson.
Here.
Anderson here. Glazer. Leno. Here. Leno here. Liu. Monning. Stone.
Madam Chair, I move the bill.
Stone here.
Bill has been moved. Please call the roll.
Hancock.
Aye.
Hancock, aye. Anderson.
Aye.
Anderson, aye. Glazer. Leno. Aye. Leno, aye. Liu. Monning. Stone. Stone, aye.
Thank you. Good bill. Thank you. Assemblywoman Kim, item 19. There is support on both sides for this, too.
Oh, well, thank you, Madam Chair and the members of the committee. I'll take that. And I'll just introduce Ms. Sarah Debkowski from Santa Cruz District Attorney's Office to say a few words.
Thank you.
Madam Chairwoman, members of the committee, my name is Sarah Debkowski. I'm the Assistant District Attorney from Santa Cruz County. I've been a prosecutor for about 7 years. When domestic violence perpetrators violate protective orders, they should be charged and punished under the appropriate domestic violence contempt of court section, which is Penal Code Section 166C1. However, under the protective orders issued under the domestic violence code discussed in this bill, they're not currently listed under the appropriate subsection. Legislators have done wonderful things for domestic violence victims. This just seems to be an oversight. It's important to understand the context for when these orders are issued, and they're typically issued under two circumstances. First, when the perpetrator is sentenced to prison, when the injury or the priors are significant enough that they should go to prison, or two, when the victims need longer protective orders than the 3 years of probation, including for up to 10 years. These are some of the most violent offenders that we're talking about. And without this correction in legislation, they could actually receive a lesser punishment than other domestic violence perpetrators, a lesser punishment than someone convicted of a misdemeanor or someone who doesn't receive jail. Punishment that would not include the appropriate batters treatment, include the appropriate volunteer service hours, or the fines and fees that go to the women's shelters. And they could receive punishment that does not include the appropriate therapeutic components as well. The punishment and consequences should be the same across the board when people violate domestic violence protective orders. I ask you to close this loophole, and for that reason, I urge your aye vote on this bill. Thank you.
Madam Chair and members, Corey Salzillo here on behalf of the California State Sheriff's Association in support of the bill.
Thank you. Others in support?
Sean Hoffman with the California District Attorneys Association in support.
Nicole Wertelman on behalf of the Orange County Board of Supervisors in support.
Thank you. Speakers in opposition to the bill? Seeing and hearing none.
Move the bill.
The bill has been moved. Would you like to close?
Yeah, I just want to thank the committee for supporting the bill, and I just want to tell you that the women also deserve the same rights and protections granted to our elderly and other victims, and this bill does that, so thank you very much.
Thank you. Okay, the bill has been moved. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson? Aye. Anderson, aye. Glazer? Leno?
Aye.
Leno, aye. Liu? Monning? Stone? Stone, aye.
Madam Chair?
You.
I'm sorry, I'll let you finish.
I was going to say that bill has enough votes. We'll hold the roll open for the absent members.
Madam Chair, excuse me, I move the consent calendar.
The consent calendar has also been moved. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson? Aye. Anderson, aye. Glazer? Leno?
Aye.
Leno, aye. Liu? Monning? Stone? Stone, aye.
Okay, item 3, Assembly Member Chow.
Thank you very much, Madam Chair and Senators. This morning, I'd like to present AB 1662. AB 1662 protects people from hit-and-run drone accidents by requiring drone operators to remain at the scene of an accident and provide their name, address, and a valid identification to the victim and to the police. Drones are becoming more prevalent and are used for a wide range of purposes, from recreation, agriculture, to viewing traffic congestion or storms. The Federal Aviation Administration estimates that about 1 million drones were sold just during this past holiday season alone. With the increasing use of drones, we are seeing more drone accidents as well. Under California law, motor vehicle drivers are required to stop and provide identification and contact information if they're involved in a car accident that causes injury or property damage. Any driver who flees the scene of an accident may be charged with a misdemeanor if the accident involves property damage, or a felony if the accident involves a personal injury. AB 1662 applies the vehicle hit-and-run laws to drones, since they are just as capable as cars are of causing personal injury and also property damage when they fall out of the sky or get too close to people. So with that, I respectfully ask for your aye vote.
Thank you. Witnesses in support.
Madam Chair, Richard Harris on behalf of the San Diego International Airport in support.
Thank you. Others in support? Speakers in opposition to the bill?
Madam Chair, members, Samantha Corbett on behalf of the Electronic Frontier Foundation. As noted in the analysis, we are in opposition to the measure for a couple of reasons that we believe are fixable. For one, this bill would, we believe, trigger reporting requirements for accidents that involve drones in recreational activities, particularly recreational activities where the intent of the activity is actually to compete and cause damage to drones. So it seems a little pointless to apply it in that instance. We believe, as again reflected in the analysis, that could be easily remedied with an amendment. In addition, the other issue that we have with the bill is that it would exclude law enforcement and first responders from the bill's reporting requirements. We understand in some situations that may in fact be necessary. However, we feel a total exclusion is unwarranted at this point. And so until those two issues are addressed, we will remain in opposition. Thank you.
Thank you. Are there others in opposition to the bill? Seeing and hearing none, are there any questions or comments from committee members? Senator Stone.
Thank you, Assemblyman. Forgive my voice, I'm recovering from a cold. Can you respond to the testimony of the young lady about the recreational use and the competition where you can have some damage that is amongst friends, if you will? Is that something you're willing to take an amendment on to exclude them?
Yeah, as it stands now, the law actually doesn't apply to that situation because during in those situations, there's usually an agreement between the parties or among the parties to compete or fight. So the law really doesn't apply to that situation. But we're willing to look at the situation more closely. In fact, we've been working with EFF for the last month or so, and we've been waiting for some amendments.
Maybe make it a little bit more explicit. I'd recommend that. And with that, I'll move your bill.
Thank you.
Sorry about that. Were you going to respond to the question?
Sure. I did the response.
You did.
Yes.
Satisfactorily.
If you like, I could repeat the answer as well.
Yes. Could you just say it briefly again? I'm sorry.
Absolutely. We'll be very happy to work with the opposition on defining the language a little bit more. But in situations where drones are being used to compete, the law as it stands now does not apply, but we'll be happy to make it more explicit as well.
Okay. I would note this is a due pass to appropriations.
Move the bill.
The bill has been moved. The motion is due pass to appropriations, and hopefully you'll work with the opposition on clarifying some of that language.
Great. Thank you.
Thank you. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson? No. Anderson, no. Glazer?
Aye.
Glazer, aye. Leno?
Aye.
Leno, aye. Liu? Monning? Stone? Stone, aye.
Okay. That bill has enough votes to pass, and thank you very much. Next, we have Assemblywoman Weber, item 28.
Thank you and good morning, Madam Chair and members. I'm here to present to you AB 2298, CalGang database bill. Under current law, California law enforcement agencies are able to collect personal information to label and track hundreds of thousands of people suspected of gang membership in order to target them for gang suppression. The largest system for assessing this information is the CalGang system, which is now used by over 6,000 law enforcement officers in all 58 counties. Gang suppression strategies employed by law enforcement, including gang databases, have existed in California for over 30 years without consistency or transparency in their application, without meaningful data reporting, and without any assessment of their impact on the criminalization of youth and communities of color. Nearly 20% of the people of CalGangs are African American and 66% are Latinos. Since only 6.6% of Californians are African Americans and just 38.1% are Latinos, this represents an alarming racial disparity. In 2013, Senate Bill 458 by right began addressing these concerns for young people by granting minors the right to know if they are in the database and to challenge their designation. However, people 18 and older still have no right to be notified, inquire about their...
There's little outside conversations going on here. It's a big room. We have a lot of bills. Please go outside if you want to have a conversation in the back of the room. That means the people back there talking. It's very disconcerting. Thank you very much, Assemblywoman.
Thank you, Madam Chair. In 2013, Senate Bill 458 by Senator Wright began addressing these concerns for young people by granting minors the right to know if they are in the database and to challenge their designation. However, people 18 and older still have no right to be notified, inquire about their designation, nor have an opportunity to appeal their designation. While law enforcement claims GalGang and other databases are a secret surveillance tool that isn't publicly shared, the label dramatically impacts the way people are seen and treated by law enforcement, and in turn transforms the way people are perceived by their neighbors, school, employers, and landlords. In addition to subjecting individuals to gang suppression, discrimination and exclusion highlights above, gang allegations can negatively affect access to immigration relief, such as the Deferred Action for Childhood Arrival, which we call DACA. Sociologist Anna Munez says, unfortunately, what results from the use of tools such as gang databases and gang injunctions is the law enforcement agencies target groups and people instead of criminal acts and before a criminal act occurs. The purpose of this bill, AB 2298, will place California on a trajectory that strengthens community police relations and transparency by, one, extending to adults the current requirement that youth under 18 are given, as well as the opportunity to contest inclusion in a shared data gang base. It removing individuals from the gang database after 3 years without a convicted violation of California Street Terrorism Enforcement and Prevention Act. And 3, it improves transparency by requiring the California Department of Justice to post online each local law enforcement agency's annual report on gang database demographics. This bill would not, however, impede active law enforcement investigations. Law enforcement would not have to notify an individual if it would compromise an active criminal investigation. And additionally, law enforcement would not need to create a new notification process, since each agency should have a mechanism in place due to the right bill. We have here to support this. AB 2298 is co-sponsored by Youth Justice Coalition, Urban Peace Institute, Policy Link, Coalition for Human Immigration Rights of Los Angeles, and the National Immigration Law Center. Witnesses here to testify is Shuming Cheer from the National Immigration Law Center and Juan Pena, a young man personally impacted by CalGang database. Okay.
Good morning. My name is Shiming Cheer, and I'm a senior staff attorney with the National Immigration Law Center. So there are many reasons to support AB 2298, and I'll briefly discuss 2 of them. First of all, this bill furthers due process. Adults who are on a gang database have no way to know whether they're on the database and no way to challenge their inclusion. This is similar to the secretive and overly broad no-fly list, where many travelers who pose no security threat whatsoever are denied boarding and have no way to find out why they're on the list. It's very easy to erroneously label someone a gang member. Erroneously documented persons are left without recourse, and being on a gang database can lead to very serious legal and social consequences, such as increased probability of criminal conviction, possible sentence enhancements, loss of employment, and other stigmatizing effects. Secondly, gang databases raise serious constitutional issues. The criteria that law enforcement uses to enter someone into a gang database is vague, overly broad, impinges on the right to free association, and suggests guilt by association. The threshold to enter somebody into the CalGang database is extremely low and requires no convictions or even arrests. In fact, a person who meets just 2 of 9 criteria can be entered into the database, and that criteria includes being seen frequenting gang areas and being seen affiliating with documented gang members. These are broad circumstances that could sweep up almost everybody in a particular neighborhood. AB 2298 would also not interfere with law enforcement's ability to continue to do their job. This law in no way affects law enforcement's ability to place people on the database. Rather, it holds them accountable for each person they add to the database and ensures that there's oversight of the process. As Dr. Weber mentioned, within the bill, there's actually a specific exemption protecting law enforcement from sharing information with people if that information would compromise an active criminal investigation. Ensuring that the information in these databases is accurate will actually improve the ability of law enforcement to use the databases as a tool in policing and prosecuting gang crimes. So for these reasons, I urge you to vote aye on AB 2298. Thank you.
Hello, my name is Juan Peña. I'm a member of the Youth Justice Coalition. We're honored to be co-sponsors of Assembly Bill 2298. I have never been arrested. I don't have any gang-related tattoos. I have no nickname and claim no neighborhood. I have never been a member of any gang. I graduated high school, work, and helped my aunt to support my family. But I still feel as the police see me as a gang member. I was born in Mexico and came to the United States when I was 7 years old. I grew up in Wilmington in the South Bay of Los Angeles. When I was 10 years old in the 4th grade, I was handcuffed and detained for a few hours by the police. I didn't speak English very well, so I didn't understand what was happening. But I was very afraid the police would find out I wasn't born here and would send me back to Mexico. Because I grew up in a gang junction zone, police regularly stopped us, all of us, and asked us where were we from. In other words, asking us what gang we were from, what our nicknames were, who our family and friends are. Sometimes they took pictures of us and filled out small white cards that I now know are called field interview cards. Being undocumented, I didn't dare to challenge these stops. When DACA, Deferred Action for Childhood Arrival, was made possible by the federal government, I was so excited. I started to fill out my DACA application several times. I thought about applying to the Marines and went to talk to a recruiter. But every time I thought about the background checks, I thought about what would happen if I was on a CalGang database. The federal order issued by President Obama ensures that Immigration and Customs Enforcement puts anyone labeled as a gang member, associate, or affiliated on top of their deportation list. AB 2298 will make it possible for me to walk into any police station and find out if I am on a shared database, gang database, and to challenge it if I am. Clearing my name would mean I could submit my DACA application, join the military, and apply for other opportunities without fear. There are over 150,000 people on the CalGang database, tens of thousands of them just like me, whose only crime is being a young person of color without documentation, raising a community with an aggressive war on gangs. I hope you will stand with us and vote yes on AB 2298. Thank you.
Good morning, ladies and gentlemen. My name is Dennis Smiley. I'm a detective sergeant with the Sonoma County Sheriff's Office and one of the operators of the CalGang database, and I have been since before it existed, so over 20 years. CalGang has always been operated under pursuant to Title 28 of the Code of Federal Regulations, Section 23, which is the Federal Criminal Intelligence Sharing Guidelines. The system has always been operated that way and has for use only by law enforcement and then only by officers that are trained in that system's use and that have a right and need to know the criminal intelligence information that's contained in that system. That information comes 99% from, as this gentleman mentioned, field interview cards and police reports. Those are the source documentation for those entries into the CalGang system. CalGang is just a pointer system back to that information. This gentleman, while I feel for his plight, there's no evidence presented before you that he's actually in the CalGang database, nor would I be able to share with you if he was. That would be an unlawful release of criminal intelligence information that we don't do beyond law enforcement. And we never have. As far as reporting requirements are, we've responded to every Public Records Act request that we've received over the last 20 years, all the way up to the governor's office and all the way down to any citizen that requests information out of CalGang, statistical information out of CalGang. CalGang is the only database out there that gives us any statistics on the gang picture within California. AB 2298 will require us to only maintain a database of convicted gang members. We already have that. It's called...
Sir, excuse me just one second. You jumped in right as the chair was leaving and passed the gavel. One second. Who are you and you're with whom?
My name is Dennis Smiley, S-M-I-L-E-Y. I'm a detective sergeant with the Sonoma County Sheriff's Office, and our office is one of the operators of the CalGang system.
And you're in support or opposition?
In opposition of AB 2298.
We're going to ask you, we're going to take everything you've said on record. Thank you for it. We're not through with the...
I'm sorry.
So First of all, I'm sorry, I did not get your name, young man. I'm sorry.
Juan Peña.
Peña?
Juan Peña.
Juan Peña, thank you very much for your testimony. It was very compelling. I know it takes some courage to be here today, so we thank you very much.
Thank you.
Are there others in support of Assemblywoman Weber's bill?
Hi, my name is Joseph Vigela on behalf of CHIRLA, the Coalition for Humane Immigrant Rights of Los Angeles, proud co-sponsor of this bill. Thank you.
Thank you.
Good morning. Good morning. Ronald Coleman here on behalf of the California Immigrant Policy Center, also here in strong support. Thank you.
Thank you, sir.
Good morning. Josh Green from the Urban Peace Institute in Los Angeles, proud to co-sponsor this bill.
Thank you, Mr. Green.
Good morning, everyone. My name is Alexandria Alex. I'm from Youth Justice Coalition, and I support AB 2298 because it affects my community and my youth. Thank you.
Thank you.
Hi, my name is Tierra Early. I'm from Youth Justice Coalition. Please support this bill.
Thank you.
John C. Smith, ACLU of California, in strong support of AB 2298.
Thank you, Mr. Smith.
Kim McGill, also from the Youth Justice Coalition, proud to be a co-sponsor of this bill.
Thank you, Ms. McGill.
Rosa Akil with Policy Link and the Alliance for Boys and Men of Color, very proud to sponsor this bill.
Thank you.
Dennis Cuevas Romero here with the Hernandez Strategy Group on behalf of the California Attorneys for Criminal Justice in strong support of this bill.
Thank you, Ms. Romero.
Jeremy Hinkson with the California Civil Liberties Advocacy, and we strongly support this bill.
Thank you, sir.
Samantha Corbin on behalf of Electronic Frontier Foundation, also in support of the bill.
Thank you.
Philippe Osagai with the California Public Defenders Association, also in strong support.
Thank you, Mr. Osagai. Are there any others who would like to speak in support of Assemblywoman Weber's AB 2298? All right, we will move to opposition. And, sir, if you would like just to take 30 seconds to conclude, we'd be happy to have it.
I'm sorry.
If you'd like to take about 30 seconds to conclude, we're happy to have it.
I've essentially said my piece. My colleague here may.
I very rudely cut you off, so I wanted to.
And I apologize for not being familiar with the operation of the chamber.
Sure. Okay. Proceed.
Also with me, I have letters of opposition from several law enforcement agencies and a couple of cities that were actually faxed to all of your offices late last night, but I have 20 copies here. I'll be happy to leave with Sergeant at Arms.
Okay. We'll take some other oppositional comments, and then I'll have a question for you.
Very good.
Okay. Others in opposition?
My name is Joel Cobb, Detective, Fresno County Sheriff's Office, in opposition of this bill. I am also one of the node administrators for CalGang out of the Fresno area, responsible for 11 counties in the Central Valley. Just two quick issues with this. With CalGang, what it cannot be used for. It cannot be used for any kind of blocking any type of social benefits, welfare, immigration, anything along those lines. We do not allow it to be used that manner. We have never received any, in the 20 years of it being in existence, we've never received any complaints of it being used in that fashion. The California Gang Node Advisory Committee is the group that oversees CalGang. It's a group of 7 or 8 of us throughout the state. We meet 3 times a year. We in a public forum pursuant to the Brown Act, and we still to this date have never received any complaints for that. That's it. I'll pass. Yeah.
So feel free, either of you, thank you, Mr. Cobb, for your presentation. So you've told us all the ways in which it cannot be used. If you could just, and you probably already touched on this in your statements, if you could just remind the committee the ways in which it is used.
The system is used to, and where it really shines is identifying the suspect in whodunit in an unknown case. So it's used by specifically trained law enforcement agents with a right and need to know in a criminal investigation only.
With reference to Mr. Pena's comments, if I could ask you this, if by fact of your family circumstances you lived in a certain neighborhood and you, not unlike Mr. Pena, found out that you were on the list and you had no way to get off, or maybe you think there is a way to get off, and there was no due process with the fact of your being on it. Would you think that fair or just? And would you think there needs to be anything done about it?
Well, actually, the question is due process due in a system that doesn't deny life, liberty, or property? The system is only used for the investigation of criminal offenses. That due process is the trial, where that information is presented in a public trial before a judge or jury. Mr. Pena, 28 CFR 23 requires information with no new, and we actually take it a little step farther. We require another of the criteria to renew to refresh the record. But if there's no new criteria within 5 years, the record is purged automatically. And to tell you the truth, we've purged more records than we currently have, probably twice as many records than we currently have.
Thank you. Assemblymember Weber, could your first or second presenter come back up to the table? I know they just sat down. I wanted to ask.
I think they've been taken back and forth.
Right.
Sergeant, so yes, very well. Yeah.
Sure. And we'll get to all the other opposition. I just wanted to ask a few questions. So if you could just respond. So what we're hearing is that the analogy with the no-fly list is not an accurate one because according to the opposition, since the no-fly list does restrict you from flying, the opposition doesn't believe that there's any restriction of life, liberty, or anything else by being on the list. So I just wanted to see if you wanted to respond to that.
Sure, and I'll respond to that from the immigration perspective. As Juan was testifying, somebody who's alleged to be a gang member, and that's just an allegation, not even necessarily a gang-based conviction, would not be eligible to qualify for certain immigration benefits, such as the Deferred Action for Childhood Arrivals program, which is the program that the president created in 2012. Also, being an alleged gang member makes somebody what's called an enforcement priority for the Department of Homeland Security. So that's who the Department of Homeland Security would actively go after in terms of seeking their detention and deportation. So there are very serious consequences that stem from being on a gang database. And this denial of immigration benefits and potential deportation are just a few of those consequences.
Go ahead.
Oh, Kim McGill from the Youth Justice Coalition, thank you. The other thing that we would add is that this information is shared in real time with other law enforcement. So it's not just California law enforcement that has access to it. It includes the FBI, alcohol, tobacco, and firearms, and definitely in this case, Department of Homeland Security, Immigration Customs Enforcement. So the data doesn't require, again, an arrest or anything more serious than just having been stopped on the street and having law enforcement suspect you of this. The other thing is that we have members who have applied for jobs that require a more significant background check that have also been impacted. So we know of 2 young people that applied for EMT positions. That's kind of an extension of law enforcement, but not law enforcement directly. Obviously, anyone that applies for military or law enforcement, it's also coming up. So it has real employment consequences. And then while we don't have the direct link for public housing, we do suspect, given the number of concerns that are being raised with us, that it impacts families' ability to get into and definitely to stay in public housing.
Thank you. So, sir, do you disagree with any of those statements? Or
Yes, I do. I disagree with all those statements.
With all of them, really?
Yes, ma'am. Yes, sir.
Quite a disagreement. Okay. We'll get back to that in a little bit. Others in opposition?
Mr. Chair and members, Matthew Seiberling on behalf of the Association for Los Angeles Deputy Sheriffs, the Los Angeles Police Protective League, and the Riverside Sheriffs Association. It's our understanding through working with our Los Angeles gang unit that these records are only accessed in response to a criminal complaint. There's no access through a background check anyway, even from our own internal investigations outside of the gang unit. We respectfully request your no vote. Thank you.
Thank you, Mr. Seiberling.
Mr. Chairman, members, Randy Perry with Aaron Reed and Associates on behalf of PORAC, and we're in strong support, or opposition.
Thank you. Thank you, Mr. Perry.
Mr. Chair and members, Corey Salzillo on behalf of the California State Sheriff's Association in opposition.
Thank you.
Sean Hoffman with the California District Attorneys Association, also in opposition.
Thank you, Mr. Hoffman.
Lauren Michaels on behalf of the California Police Chiefs Association in opposition.
Thank you, Ms. Michaels.
Sean Rundle on behalf of the California Peace Officers Association in opposition.
Sir.
Chair, Member Shane Levine on behalf of the California Statewide Law Enforcement Association and Fraternal Order of Police in opposition.
Thank you, Mr. Levine. So, Ms. Weber, how would you suggest that we get to the core of this very significant, I don't mean to overstate it, but I think we've got one side saying it won't impact your life one bit to have your name on this list, and the proponents saying it has real-life significant impacts?
Well, I think you recognize the fact that if you're not on the list, if you're not in the community, you probably don't understand the impact, because in your mind, this is a good thing that allows you to do a whole lot of things that maybe you shouldn't do in a democracy, in a country such as this, in terms of targeting individuals. We've seen this kind of thing with almost in the McCarthy era, where people are put on lists. And the community that I come from, and I've lived in communities that have gang activity all of my life. So I'm not a supporter of gang activity. That's extremely important to understand. Gangs have obviously a very negative impact on people's lives and young people's lives and communities. But I also know that oftentimes in our zeal to deal with an issue, we overextend ourselves, and we end up doing more harm to individuals who are not a part of the problem, and therefore having a negative effect. We in this House, in these two houses, have really looked at and have really increased penalties for being in a gang. We have a lot of gang enhancement laws now, and that concerns me most, that a person who has no knowledge that they're in a gang, had not been notified, could be on a gang, be on a gang list, maybe engage in some activity that was a criminal activity that's not even gang related, and find themselves with gang enhancements, additional 2 years. We just passed some more bills this year. And so where it started off at initially being something that was maybe helping law enforcement to identify groups, the expansion of it, I understand from some folks who were in my office the other day, there are over 200,000 people on the gang list right now. And that's just what we think. They've been told us there's over 200,000. And those individuals could be targeted very easily when they come up for any kind of activity that's there that they have no knowledge of. This is not saying get rid of the gang database. This says notify people you're on it. Have an opportunity to appeal it, that you should not be on the list. And I can tell you from personal experience, about 10 years ago, my 20-year-old son was coming home from dinner, and the gas lamp of San Diego, he was not even in the gang territory, tall African-American male with another African-American male in his car, stopped by the police, sat on the curb, embarrassed in front of everybody, went through their entire car looking for, well, who knows what, ended up finding nothing. And then having a conversation as to why they stopped them and why were they out, the whole kind of thing. And then saying in the end, you know, we might have to put you on the gang database. And he had done nothing. He had no criminal record. He had not done anything. He was not speeding. He didn't get a ticket, nothing. This 20-year-old comes home in tears because they're going to put him on the gang database. And we were fighting this in San Diego because we had lots of kids being placed on this list without knowledge, or being told they're going to put on a list. And you have no way of finding it out. You know, I, being the person I was, immediately called the chief of police about my son, as well as about others as well. So this is the kind of thing that can happen. And I say he's not on the list, but I have no idea. Because you're never informed that that you're being put on the list. You have no notification. You have no idea as to how you get off the list if you're on there. And it can have consequences that we see every day. And surely in these two houses where we have increased criminal penalties for folks who are gang members, it happens. Last year in San Diego, 2 years ago, I guess it was last year, 182.5 was applied to a whole host of kids, because we have this law now that says if an activity occurs and you're a gang member in that if you're supposedly on the gang list, you can be rounded up. And our district attorney rounded up about 15 kids and tried to try them for a murder case, only one that had happened. None of these kids were even in the area that occurred. Some of them were kept in jail for over a year. A couple of them fought it. One of you remember was a rapper who they claimed was a gang member because he had gang language in his video, his rap songs. In the end, the judge threw it all out because he found it was horrible for what was happening to these kids. But unfortunately, about 5 or 6 of those young people who didn't have lawyers, who didn't have active advocates, basically copped a plea because they didn't want to be tried for murder. And therefore they did, I think, 15 months or something like that in jail. So there are lots of things that happen that law enforcement may not identify, that happened as a result of so-called being a member of a gang or on the gang list, without those persons having committed any crime themselves. And so while I am very much in favor of us working to make sure we eliminate gang activities in communities and all those kinds of things, I'm very much opposed to us basically targeting young people, having this list that exists that none of us know who's on it, how large it grows, when they purge it, who's being purged off, who's being put on. And I just think in terms of transparency, living in a country where none of us want to be on any list without knowledge of it, that as a result, this bill is a modest bill that simply says, if you're on it, if you're going to be put on the list, you have to notify me that I'm on it. I have an opportunity to appeal it to say it should not be on the list. And after 3 years, those lists, if you haven't engaged in any kind of gang activity or criminal activity, the list should be purged. Now, that doesn't mean you can't be put back on later on, because it's not a permanent purging. But surely, we should not be putting people on these lists that last forever, that we as a legislature, that we fund this list, have no idea how large it is, how often it's purged, who's on it, those kinds of things. And as pointed out, if there's an active investigation occurring and you're being put on the list, they don't have to notify you because we don't want to impede any active investigation. But for the sake of transparency, for the sake of the communities that are here, as you can see, a huge number of communities are opposed to this list and have dealt with this list in various organizations for the last 20 years in terms of what are we going to do with this gang database and how do we get some transparency that's there. I respectfully ask for your aye vote as a result of that.
Thank you, Assemblywoman. Senator Stone.
Thank you, Mr. Chairman. If I could ask the two gentlemen a couple of questions. I'm hearing different things with respect to the scope of this bill, and I certainly understand that if you have a kid, a child that's going to school, has lunch with a known gang member, this person is allegedly put on the list. It's being inferred that this person could end up in jail for a crime that they didn't do other than having lunch with a gang member. That seems kind of preposterous to me that a district attorney would certainly find some link to association to some crime. So I'd like you to elaborate a little bit. It can only be used for a criminal investigation, and that we've heard also allegations that people have not gotten jobs because they've had access to this list. You made it clear that this is not a publicly proliferated